Take us through a journey from 1960, briefly, from 1960 till now. If you were to do a contrast between the justice system we had then and now, what has changed and how far has Nigeria gone when it comes to justice delivery and as far as the judiciary arm of government is concerned?
Okay, thank you so much. I want to appreciate this opportunity. Looking at the judiciary from time of independence, we have grown in leaps and bounds. I want to say that we have had the longest time we had civil rule is this dispensation from 1999 to the present. With those interruptions after the independence, like we had a civil war, and then we had a long chain of military interventions. Those had their own impacts in our judicial system too. But we want to also understand that during the military interventions, it is always the judiciary has become or has always been the constant factor because of a truth. During military interventions, the legislature is suspended, but maintaining the third arm of government, which is the judiciary, as a constant star. Now, having it, being explored from time of independence up until this moment, like I said earlier, we have grown in terms of technology, we have grown in terms of population, we have also grown in terms of knowledge base and the global relevance or the global accessibility of knowledge. To that extent, I also want to say that the 21st century realities also happen to the extent that some municipal or some local incidences that happen in a particular country has become almost global, such that the awareness for rights is increased, and peer review mechanism is made easier too because there is comparative analysis almost happening online real time. It doesn't take a month, it doesn't take a week, it doesn't take days for what happened in some extreme part of the world to get across to another extreme part of the world, such that rights and liabilities for individuals as much as corporate entities are being discussed at the global level. The impact is such that the judicial system of a particular country cannot continue to remain bottlenecked within their municipal laws or within their socio-political milieu. It has now become a global factor. So it emphasizes the fact that one wrong in one corner is another wrong in every corner. To that extent, judicial officers categorized into those who are bureaucrats, who work in ministries of justice, and then those who work in the court systems, lawyers at the bar and judges at the bench. The reality of 21st century has dawned on us that we have to up our game. To that extent, I can say that it has come for us with the plus, the minus, and the gains and the responsibilities. That is how far we have gone so far.
Also in the justice system in Nigeria is that there is delay in litigation. We have one case going on for several years, and it just keeps going on like that. What are the issues?
Okay, the issues are the slow pace at which some judicial officers, learn, unlearn, and relearn. Most of those who are sitting in our upper chambers of our courts, most of them graduated or came into practice at a time when the technology that happened to us in the recent times wasn't as ubiquitous as it is today. So some of them are still learning the realities of having technological tools in aid and advancement of justice delivery. But I will also tell you that with the COVID-19, which happened to all of us all over the world as a disruption, it came with some blessings too. Following that incident, particularly to Nigeria, most courts in Nigeria adopted virtual hearing and have so amended our laws and the rules of courts to that reality. So again, talking about cases lasting in courts for more than necessary, it is against the legal principle that justice delayed is justice denied. I can understand your pains. I can understand the concerns of entrepreneurs. More recently, as has happened or as is happening presently in Nigeria, more than 307 judges of our court systems drawn from our judiciary, from the Sharia, from the magistrates, from the state and federal high court, federal capital territory high courts, and also from the federal high court itself and the court of appeal, all totaling over 300 judges, are engaged recently and ongoing in election petition tribunals. You can't imagine the delay it will cause in court dockets lying fallow in their courts. I am also a victim. Most of these cases have to do with individual rights, corporate rights, businesses, contracts, and what you can also look at from the point of view of foreign investment. If a foreign investor doesn't see with certainty the fact that policy-wise and reality-wise that he wouldn't get justice from our court systems as early as needed and as urgent as needed to protect his corporate or contractual interest, it's a minus for foreign investment. So it's a very serious concern. We must stop politicization of our courts or, to an extent, engender or evolve a system such that politicians should behave themselves. And in reality, a situation where the ballot box and the democratic system of exercising our franchise through open ballot system of voting will determine those who govern us, rather than having our leaders churned out to us through the gavels and the courtrooms. It's a serious concern, the fact of delays in justice system in Nigeria.
All right, let's look at looking at the judicial arm of government in Nigeria. What will you say about the quality and the quantity of judicial officers on the bench and at the bar as far as Nigeria is concerned?
It is also another serious concern because, talking from the bar, we are guided, regulated, and we have our code of conduct as established by the Legal Practitioners Act. That act is an act of parliament regulating the practice of law in Nigeria. Also established are the Legal Practitioners Disciplinary Committee. This disciplinary committee has the latitude to discipline errant attorneys and counsels, in fact, general practice in Nigeria. The extent it has gone in achieving that statutory mandate leaves to be imagined. A situation where determining what is fit and proper and determining what conduct has been adjudged unprofessional is a serious concern. And we have not seen as many legal practitioners of the rank of the silk being punished, because most of the infractions, so to say, and most of the shopping around for conveniences, you get, for example, the High Court of a state going to court belonging to a state, and imagine giving out judicial order that a particular politician, probably a serving governor or an ex-governor, should not be investigated by EFCC, and making such orders, making them permanent. It is laughable because it is judges that read out those judgments, and it is senior lawyers that file those frivolous actions in court. Sometimes they even file frivolous appeals, dragging a matter that is supposed to have been decided one way or the other on point of technicality, and they will drag it longer than necessary. That is on one side. The next point you raised is the question of the appointment of judges. It has also been politicized. Sometimes you see judges of character, candor, and learning remaining in a particular spot for a long time when they ought to have been elevated from one level of judiciary to the other, both at the state or at the federal level. And oftentimes you hear some languages that the governor doesn't trust him, or that he is not, or she is not malleable, that she can't be controlled. Why would a legislative officer, or why would an executive officer like the governor of a state wait until he sees a character that is usable, in quote, before that person could be promoted to a judicial office? These are realities in our times, and they are very worrisome.
Okay, because of the issues or challenges sometimes with the judiciary or legal system, some persons turn to the use of informal conflict resolution mechanisms. What are some of the main conflict resolution mechanisms we have in Nigeria, and how can they be made more effective?
Thank you. Recently, the Federal High Court, in its Federal High Court Civil Procedure Rules 2019, established the Federal High Court Alternative Dispute Resolution Court. Before then, Lagos took the lead by establishing the multi-door court, and it has spread like wildfire all over the states. Most states of the Federation has multi-door courthouse, by whatever name called, but they are for the same purposes. What are those purposes? Alternative dispute resolution. Alternative dispute resolution has to do with arbitration, negotiation, mediation, and conciliation. These are four major tributaries through which matters get resolved. And the beauty of alternative dispute resolution is that any judgment that arises or that is a product of that process is a consensual judgment. What do I mean by that? It is consent judgment because it was reached not through adjudication, but through the consent of parties. And I can authoritatively tell you also that judgments that are reached through conciliation cannot be appealed against because it is consent judgment. It is one of the fastest means of getting disputes resolved. And it is heartwarming to confirm to you that most of our courts adopt that mechanism. And it has been a saving grace from litigations lasting longer than necessary in our courts.
All right, talking about cases lingering in court, there's this advocacy for special court. One of the arguments is if this will help, because there's this saying that hope deferred make the hearts weary. Now, do you subscribe to that school of thought that there should be special courts?
Special courts for what purposes now, if I may ask? For example, the Constitution is replete with what we can call special courts too, because the judicial powers of the Federal Republic of Nigeria is vested on the courts established by the Constitution, starting from the highest court, which is our Supreme Court. And then it dovetails down to the non-courts of records. I can tell you for sure that the powers vested in these courts makes it possible that the courts can dispense justice as fast as possible. In a situation where, for example, parties has come to court and the presiding officer sees that the matter can be resolved, the court can sue motu, that is unilaterally exercising its jurisdiction by its inherent powers, refer parties to ADR established by that court. I have been a beneficiary. Most of my clients have been beneficiaries, and it's pressed across. Parties can as well on their own approach those courts or approach those multi-door courts. And the situation where resolution is reached, they can be passed through the courts back again for endorsement as consent judgment. So I can tell you that, in essence, the judicial powers vested in our courts is of a wider latitude. It gives the admin judge powers to distribute cases, allocate cases, assign cases, as the case may be. And in assigning those cases, in direct answer to your question, cases that come to court, some come as fundamental human rights protection, some come as ordinary contracts, some come regarding maritime, some come regarding banking, some come in form of crimes, special crimes like corruption. So the call and hues and cries has been made so loud that criminal courts should be established or special courts should be established for EFCC matters. I don't subscribe to that view because, for example, the National Judicial, the National Industrial Court is established particularly for labor issues. And in every of those courts, you know where to go to. But when it has to do with crimes, I know of assurance that the state high court and the state high court and the federal high court, federal capital territory high court has the jurisdiction to treat corruption cases. And like I said, the admin judge in those courts have designated divisions. Let me use the Lagos jurisdiction, for example. In Lagos State, when you file a matter at the court, at the process section, there's an ACR, Assistant Court Registrar, who, as the registrar of that court, looks into the claims and determines that this is a land matter. The case should go to land division. This is a family matter, it should go to family court. This is a commercial matter, it should go to commercial divisions. And most courts in the Federal Republic of Nigeria has those divisions. So what else? How else would you want special courts if not this way? What they are asking for is already in existence and is already in practice. Most judges in some courts have their dockets, 90% of cases assigned to them from the admin judge on a particular subject matter. And I can tell you, it has been helpful, except like ideas are very fertile and the ideas are very universal. If they come with strong arguments and it so carries the day that special courts should be established as in corruption, this and that, probably too, it can be established. But I tell you what in essence they need is regulation through the civil or criminal procedures of those courts.